Just want to let you know we'll be starting in a few minutes. We're just waiting for other individuals who have registered. So thanks for your patience. Hi everyone again. Just a reminder, we'll be starting in a few minutes. We're just waiting for a few of the other individuals who have registered for this webinar. Thanks for your patience. So good evening, everyone. My name is Margie Primero, and I'll be delivering our webinar this evening on the topic of divorce in Ontario, separation and divorce in Ontario. Unfortunately, Lisa Gelman is not able to be here with us tonight due to an urgent matter, but I know how excited she is about these webinars and how popular they're becoming. Just a bit about Gelman Associates. We specialize in family law, and we have 9 lawyers serving 4 offices across the GTA. We have offices in North York, Barrie, downtown Toronto, and Mississauga. We know that separation and divorce can be a very scary time in your life, and we know that for many it is also the most stressful. Gelman Associates understands that every divorce is unique, and we pride ourselves on going that extra mile for our clients to achieve the best possible outcomes for them. We also believe that knowledge is power, and we do our best not only to provide expert legal representation, but also to educate our clients so that this difficult journey that they're going through is made just a little bit easier. Like I mentioned before, our webinar tonight is about divorce in Ontario, and this webinar is just one example of how we are helping just to demystify that process, the divorce process in Ontario. There continues to be a lot of interest expressed for this webinar, so Gelman Associates has scheduled another session to be held on Wednesday, January 9th at 11 a.m. So just a little bit about myself. My name, like I said, is Margie Primero. I am an associate lawyer at Gelman Associates, and I've been practicing law, family law, for about 5.5 years now. I invite you to check out my bio and the bios of my colleagues on our website at www.lisagelman.com, and under the click the tab under Our People. You can also contact me at my email address, which is mprimero@gelmanlaw.ca. So just a little bit of housekeeping before we begin. To better see the screen, please feel free to minimize the dashboard on the right of your screen. If you can see my cursor here. by pressing the orange arrow near the top and to the left. You can also restore the dashboard by pressing the arrow once more. Towards the end of the webinar, we'll have time for some questions and answers. The questions can be posted by typing your questions in the chat messaging area of the screen. And again, I have my cursor here. It's located at the bottom right of your screen. You can post your questions at any time during the webinar, and we'll do our best to get to all of them during the webinar. And if we don't have a chance to do that during the webinar, I will respond by email. Just a little disclaimer before we begin. Just as a reminder to everyone that the presentation that we're giving today is for information purposes only. And if you have a family law matter that you're currently facing, please seek out the assistance of a lawyer. We at Gelman Associates are experienced family lawyers who can assist you with all aspects of your family law matter. So to begin, our first topic is divorce in Ontario. Now, I think there's a lot of misconception in the public, in the public about divorce and separation. A lot of people seem to think that they're one and the same, but they're not. Divorce is really just a procedure through which two married people become unmarried. It's just basically paperwork that will allow one person or both people to say that they're no longer married to that person, and it allows them to marry someone else if they so choose. The most common ground for divorce in Ontario is marriage breakdown. On the basis of marriage breakdown, you and your spouse must be living separate and apart for at least 1 year before a court will grant your divorce. The other less common grounds for divorce include adultery and physical or mental cruelty or abuse. Now, like I said, divorce and separation are two separate things. While I said that you can't get your divorce granted until you've been separated from your spouse for at least a year, all the other issues that come up from your marriage breakdown can be dealt with immediately. And there are really four main issues that most people deal with upon separation, which really form the meat of family law in Ontario. And those four issues, we'll be going through them in greater detail. They're custody and access to children, child support, spousal support, and property division. So like I said, divorce and separation are two different things. Divorce is a procedure. What is separation? Well, separation is really all the things that happen when your marriage breaks down. And separation happens when two married people live separate and apart with no prospect of reconciliation. A lot of people don't know this, but you can live separate and apart and still remain living under the same roof. If this is the case, your date of separation would be determined by looking at all the facts. It's not black and white. In some cases, it's not black and white on determining when the date of separation is. The courts would look at, was the couple still sleeping in the same bedroom? Were they still resuming marital relations? Did they tell family and friends that they were separated? Did one of them or both of them start dating other people? So looking on the facts, was this couple living separate lives, and therefore can they be said to be living separate and apart under the same roof? So the criteria really is that for separation is that there is a breakdown in your marriage to the point where you live separate lives and there's really no prospect of reconciliation. But having said that, the law in Canada, the Divorce Act, and the law in Ontario is geared towards reconciliation of married spouses who are separating. And what do I mean by that? Well, the law allows you to try to attempt to reconcile with your spouse without affecting the 1-year period of separation. So if you and your spouse resume cohabitation or resume living together as a married couple for a period or periods totaling no more than 90 days for the purpose of getting back together or for the purpose of reconciliation, it will not affect the period you were considered to be living separate and apart. To give you an example, if you and your spouse begin living separate and apart on January 1st, 2013, and in an attempt to reconcile, you decide to live together again on February 1st, but then after a month, you decide this is really not working out, so on March 1st, 2012, you say, this is it, we're done. If you and your spouse don't continue living, don't again come back together for more than 90 days after March 1st, then your date of separation would remain January 1st. This allows you to give some period of time to reconcile without affecting that period of time of the 1-year period to get a divorce. As I previously stated, a court will only grant a divorce on the basis of marriage breakdown or separation if you and your spouse have lived separate and apart for at least 1 year. But again, all the other stuff that I mentioned, which we'll be going into great detail, can be dealt with immediately. So the first issue that can be dealt with immediately is spousal support. Spousal support can be claimed by either spouse. Gone are the days when, the husband was sole breadwinner. Both husbands and wives can pay and receive spousal support. It can also be claimed by married spouses or common law spouses, provided that the common law couple have been living together for at least 3 years or have a child together. Now, spousal support is not automatic like child support. In other words, it has to be claimed by the spouse who's seeking to receive the support. It doesn't mean that because you're married to someone who probably earns 3 times more than you, it doesn't mean that you'll automatically receive spousal support upon marriage breakdown. You have to ask for it. Now, in deciding whether someone who's asking for spousal support is entitled or should be getting spousal support, the courts would consider a lot of different factors. First, they'll look at the need of the person looking for the support and the spouse's ability to pay that support. So if you claim that you need the support and you could prove you need the support, it might be that you won't be getting the support if your spouse does not have the means to pay that support. The courts will also look at any kind of agreement, either a verbal agreement or an arrangement that you had during your marriage that may have created an obligation on one party or one spouse to pay support to the other, depending on the circumstances of the case. Excuse me. For example, if the parties agreed that one person would stay home with the children, or one spouse wanted the other person to stay home with the children, that could create an obligation for spousal support if the marriage breaks down. The courts will also look at the facts and circumstances of the case to see whether a spouse who's asking for support should be somehow compensated upon the marriage breaking down for foregoing or for sacrificing career or educational opportunities during a marriage. So for example, for the stereotypical Leave It to Beaver scenario, I don't know if any of you are old enough to remember that show. June Cleaver was a stay-at-home mom, and in that case she would be entitled to spousal support because she, probably gave up a lot of educational or career opportunities to stay home and care for Wally and the beaver. So her need for support is connected to her role during the marriage, which is also connected to what I just said before, the arrangement between the parties during the marriage. The courts may also look at any economic disadvantage that is suffered by one spouse, the spouse claiming the support in general, and also as a result of the marriage breakdown. So for example, if one of the spouses has a serious illness that prevents them from him or prevents the spouse from being able to support himself or herself, that fact may affect the amount of the support and how long that support would be paid. So the next issue is child custody and access. And there are really two aspects of custody. And a lot of people, when you say custody, they think they have a different understanding of what custody means. There's legal custody and physical custody. Legal custody is really the authority to make decisions about the child's life. The parent who has legal custody of a child has the authority to make decisions regarding the child with respect to the child's education, that child's medical care, religious upbringing, where that child would live, and all the other important aspects of that child's life. Physical custody, on the other hand, is related to access, and it involves the amount of time that the child spends with each parent. Obviously, the parent who has legal custody also has a lot of control over the physical custody of that child. Legal custody arrangements, there are various ways to arrange, well actually not various, but there's two ways to have legal custody of a child. There's joint custody, and that's where both parents equally share the authority to make decisions about the child's life. The parents jointly make the decisions. Now, joint custody is appropriate where the parents are generally in agreement regarding the child's education, medical care, religious upbringing, where the child will live. If the parents can make the joint decisions in a generally amicable fashion, and they're generally in agreement about what will happen to this child, then joint custody is appropriate. On the flip side of that, if the parents cannot agree on the major issues regarding the child, for example, I've had cases where the parents don't agree about the religious upbringing, they don't agree about where the child will live, they don't agree about where the child will go to school, then, or if the parents just cannot communicate, they cannot communicate in an effective manner to make decisions jointly, then it might be more appropriate to grant sole custody to one parent. Now, physical custody or access, there are various ways to arrange that. If one parent has custody of the child, then the other parent usually has access. So the parent who has custody is usually called the custodial parent, and the other parent is usually called the access parent. So just a few examples of different ways to arrange access. You can have a set access schedule where the access parents' dates and times of visitation are set out. Usually like Wednesdays 5 to 9 p.m. and every other weekend from 9 a.m. to 6 p.m. or this kind of arrangement is ideal in cases where there might be some issues between the parents. It just helps everyone know where the children will be, and it eliminates any kind of potential conflict between the parents. Another way to have it is reasonable access, which is more flexible, and it can be determined by the parents as they go along. They play it by ear. Obviously, this is ideal in a joint custody arrangement where the parents are amicable and where the parents actually live close together so that they can, it's more practical to be able to shuttle the children from one household to the other. Another way is to have supervised access, and supervised access is necessary in cases where the access parent has various addiction issues. If there's a problem with alcohol, with drugs, when there's a real serious concern about the access parent's ability to parent, then supervised access might be appropriate. Now, the issue of custody and access really is determined if it has to be determined by a court, and usually it's if it's determined between the parties, what they have to look at is what's in the best interest of the children. It's not what is convenient for the parents. It's not what the parents necessarily want. It's what is in the best interests of the children. And what does that mean? What does best interest of the children mean? Well, the best interest of the children is really a bunch, a number of factors that the courts will look at. They'll look at the needs and circumstances of the child or children involved, including, the love, the affection, the emotional ties that the child has with the parents and the extended family, grandparents, aunts, uncles. They will consider the views and preferences of the child, if the child is able to express those in a meaningful way. They will look at the permanence and stability of the family unit, which is being proposed. If one parent is suggesting that the child should be with them most of the time, that they should have sole custody, the courts will look at, what kind of stability and permanence can this person provide to these children or this child. They'll look at the ability and willingness of each person to provide the child with guidance, education, necessaries of life, and if the child has special needs, to what extent can that parent provide for those special needs. And they'll also look at the ability of the parent looking to have custody or access of the child. Is there, for example, like I mentioned, does the parent have addiction issues that will prevent them from being able to parent the child effectively and in an appropriate manner? So these are just a bunch of factors that the courts will look at that fall under this umbrella of best interests of the children. Now, the next topic is child support. Now, there's two forms of child support. There's basic child support, and that's based on the payor's income. In every province, there is a table which tells you how much a parent should be paying or must be paying based on their income and the number of children that are entitled to support. On our website, right here at www.lisagelman.com, child support calculator, there's a really cool calculator that you can use to determine the child support payable in your case. Now, the basic child support covers the child's basic needs, shelter, food, clothing, and that's assumed that the amount that you pay based on a table will cover that for your child while they're living with the other parent. Section 7 expenses is the other part of child support. So there's basic child support, and then there's Section 7, we call it Section 7, and that's for special and extraordinary expenses. As you know, it's any of the expenses that go beyond the child's basic need for food, shelter, and clothing. So, for example, any extracurricular activities that the child is involved in, any other extra educational expenses that are required for the child, any medical expenses that are not covered by insurance, medical insurance, those are considered special and extraordinary expenses. Daycare is another example of a special and extraordinary expense. Now, the amount of child support is based on each parent's total income. And the amount of child support is also affected by the access arrangement. So meaning that the amount of support that is payable in each case depends on how much time the child spends with each parent. So if a child spends less than 40% of the time with a parent, that parent has to pay child support to the other parent at the full table amount. However, if the child spends an equal amount of time, let's say 50-50 with each parent, then the parent who has the higher income will generally pay the other parent a set-off amount. And what does set-off mean? What does a set-off amount mean? So just to illustrate, in this case, let's say that parent A earns an income of $100,000 per year, and parent B earns an income of $60,000 a year. Let's say that based on $100,000, the table amount is $500 a month of child support. And let's pretend that with $60,000 income, the table amount to payable is $300 a month in child support. So parent A, earning more than parent B, has to pay parent B the difference between the two amounts, which is $200 a month in child support. $200 is a set-off. So having said that how much time each parent spends with the children or the child affects how much child support is to be paid, you have to be aware that a parent has to pay child support regardless of whether he or she sees the children or not. So if a parent has sole custody of the child and that parent tells the other parent that he or she can't see the children unless they pay child support, this is wrong. The parent's right to see the child stands regardless of whether they pay child support. It's also wrong for one parent to argue that they shouldn't have to pay child support because he or she they don't see the child anyway. The parent's right to see the kids does not depend on child support, and the children's right to support from their parents does not depend on whether they have a relationship with the parent paying support or not. And that's important to remember. The next issue that usually comes up upon marriage breakdown is property division. Now, in Ontario, the division of matrimonial property, or dividing property in family law, applies only to married people. If you're not married, there are ways for you to get a portion of your ex-partner's property, but it's not automatic like it is for married people, and it's a lot more difficult to get. So when two married people separate, they can ask that the property they accumulated during a marriage be divided between them. How does it work? Now, to really simplify a pretty complicated, or it could be a complicated process, let's take a very simple example. So in this example, let's pretend that husband and wife, when they married, neither of them owned any assets. Let's pretend that when they walk down the aisle, both husband and wife, being fresh out of university, have student loans, and so they both have debts of $10,000 each when they married. And let's pretend in this example, to further simplify it, that they don't own the home that they are living in when they separated. So in this example, the husband, when they separate, when the couple separated, the husband has assets of $200,000, and the wife has assets of $100,000. And let's say that when they separated, the husband has around $50,000 in debt, and wife does not have any debt. In this example, if the husband had assets, let's say, of $10,000, you could see here that $10,000 would be deducted from this amount. But to simplify this process, to make this a simple example, neither of them had debts, assets at marriage. So at the end of the day, the husband has a net family property of $140,000 and the wife has $90,000. What net family property really is a fancy way of saying the net increase in the value of these people's individual assets during the marriage, their individual interest in the assets during the marriage. So in this example, husband has a higher number, has a higher net worth, net increase in the value of his assets during a marriage. So he has to pay the wife half the difference. The difference is $50,000, so he owes the wife an equalization payment of $25,000. Again, this is a very simple example. And again, if the husband had $10,000 worth of assets at marriage, this number here would be $130,000. The $10,000 would be deducted from his net family property. Okay? Now the other thing to remember, and the reason why we didn't include the matrimonial home in the first example, is because the matrimonial home has very special status in the family law in Ontario. And to illustrate this, we have another very simple example. Let's pretend that in this example, spouse A owns the matrimonial home at marriage. Okay, so spouse A is bringing the matrimonial home into the marriage. Let's say that obviously assets at date of marriage, it's a matrimonial home. Usually it would be included here. Let's say the house is worth $100,000. Neither spouse owns any other assets nor have any other debts other than the matrimonial home and mortgage. So spouse B, who at date of separation does not own the home, only spouse A owns the matrimonial home at separation and at marriage. Spouse B is 0 all the way down here. Because it's a matrimonial home, spouse A is not able to deduct the value of the home at marriage, so that's why it's 0. Like I said, let's pretend that the matrimonial home was worth $100,000 when the couple married. Well, it cannot be included here because it's a matrimonial home. Spouse A would, if the couple has no other assets and no other debts, spouse A would owe spouse B an equalization payment of $100,000, which is half of the house. Okay? If this was not the matrimonial home, and like I said, the house was worth $100,000 at marriage, then spouse A could deduct the $100,000 from that amount and would only owe spouse B an equalization of $50,000, which is half of $100,000. But in this case, it's a matrimonial home, and this is to illustrate the special status of the matrimonial home. Now, the third issue you have to deal with when you're dealing with property division under family law in Ontario is financial disclosure. I cannot emphasize more how important it is to deal with financial disclosure. Regardless of what route you take to resolve the issues of property division upon marriage breakdown, regardless of whether you decide to go down the route of separation agreement or mediation or court, you have to exchange financial disclosure with your spouse. So, and again, it's a complicated process, and you should seek the assistance of a lawyer, even if that's the only, if you have no funds to hire a lawyer to assist you with your entire file, you should at least get a lawyer to help you with the financial disclosure, because it is a complicated process, and it is so essential when it comes to determining the property division in a matrimonial matter, a family law matter, and regardless of which way you decide to resolve your issues. So financial disclosure is very important, and you really should get help preparing your financial disclosure from a family lawyer. I mentioned divorce. You can get a divorce. It could be granted as long as you've been living separate and apart for 1 year with no chance of reconciliation or no prospect of reconciliation. You can start the divorce process as soon as you want to, before the 1 year separation, but you will not be granted until you've been living separate and apart for 1 year. You start the divorce process by filing an application with the court. The judge then grants the divorce claim again after you've been living separate and apart for 1 year. Then the divorce order is granted. And it's usually, your divorce becomes effective 31 days from the date the divorce order is granted. It's important to remember, and I'm going to repeat myself, but it's important to remember that all the other stuff that you have to deal with, custody and access of children, child support, spouse support, and property division, all of that can be dealt with immediately after you and your spouse separate. You don't have to wait the 1 year. You wait 1 year to get divorced, but all the other stuff that we were talking about that comes up upon separation can be dealt with immediately. Limitation periods. What does limitation periods mean? Limitation periods, it's really important to know about limitation periods because it's the amount of time you are allowed by law to make a claim for support or your share of the matrimonial property. Now, for support issues, for spousal support, there really is no limitation period to ask for spouse support, but the longer you wait, the more difficult it will become to make a claim for spouse support because the court can turn around and say, well, you went this long without asking for support, so where is your need for it? Child support, you may have a more difficult time getting all the back child support or retroactive child support that should have been paid to you if you wait on asking for child support. For property division, there are clear limitation periods for asking for property division. You have 6 years from the date of separation to ask for an equalization of your properties. And you have, or 2 years from the date of divorce, whichever is the earliest date that occurs. So 6 years from date of separation, or 2 years from the date of divorce, whichever occurs first. When can I file for divorce? Like I said before, you have 1 year. You could file your divorce. Sorry, to clarify, you can file for divorce as soon as you become separated, but it will not be granted and will not be finalized until you've been separated for at least 1 year. You have been living separate and apart for at least 1 year. So just to talk briefly about a very serious topic, and that's domestic violence. It's really important to remember that you do not have to become a deadly statistic. You don't have to stay in a violent home. It's important to remember that your safety and the safety of your children is of utmost importance, and you should deal with that first. You should seek a safe place to live or a safe place to be if you are the victim of domestic violence, and then deal with all the other stuff that we were talking about. And the statistics show that, like you say here, each year over 40,000 arrests result from domestic violence, and obviously that's just from the ones that are reported. And 12% of violent crimes reported to police in Canada are from domestic violence. And 16% of all solved homicides are a result of domestic violence. So if you are in a violent home, if you are the victim of domestic violence, take immediate action. Call the police if it's an emergency. If it's not an emergency, and if you're able to seek the advice of a lawyer first, then do that. But again, if you are in a violent situation and it's an emergency, call the police. Seek a safe place to be. You can contact a domestic violence relief agency, such as the Victim Support Line, and we have the numbers right here. The Victim Support Line can give you information and connect you to the appropriate services, and they can direct you to a safe shelter. But again, if it's an emergency, call 911. And, you know, your spouse can be, there are different ways to deal with the domestic violence. Obviously, there's criminal charges that can be filed against your spouse. But from a family law perspective, the main thing is get yourself to a safe place, you and your children, your safety and their children, and their safety, the safety of your children are of utmost importance. Then you can call a family lawyer to help you deal with all of the family law issues that we've discussed. Okay? And if you require any assistance with a legal issue involving domestic abuse, don't hesitate to contact your lawyer after you are in a safe place. Just a few tips on surviving separation and divorce. Like we said, you know, we know that separation and divorce could be, you know, a very stressful time. I once read that, you know, when they did a study on the level of stress that people experience during various events in their life, they found that separation and divorce actually caused people more stress than if their spouse had died. So obviously it's a very stressful and trying time. And to help you deal with that, you know, you should talk to friends, really surround yourself with support from friends and family during this time. Keep focused on your children. Your children obviously will be affected by this as well, and it's important to keep focused on them, and that helps you to get through the day. Stay busy, you know, go out with your friends, you know, go out with your girlfriends, go on vacation, check out the Gelman Forum. The website address is on our screen. The Gelman Forum is it's a very good source of information. You can check out the forum to see if you have a question, whether it's been answered. If you have a question that hasn't been answered, you could post the question, and you know, we make our best effort to answer it within 24 hours, and in fact, it's usually answered within 24 hours. Seek out legal assistance from a qualified lawyer, and if appropriate, seek out counseling. And you know, it's a very important thing to remember that it is a trying time, and perhaps counseling you might find counseling very helpful for yourself and for your children, perhaps. So now we have time for some questions and answers. We have a question here. Excuse me. Does it matter for custody issues, etc., who leaves the house first, especially when children are involved? Well, if you leave the house with your children, you might establish the custody and access arrangement from that point forward. The problem there is that if you, let's say, for example, in a situation of domestic violence, if the person who has committed the domestic violence is forced to leave the home, obviously a court will not want to kick the children out of the home. They will be able to stay with the parent who is at the home, who remains at the home, and that parent who remains at in the matrimonial home with the children has a better case for custody and access, because you know, it's arguable that it's in the best interest of children to stay in the matrimonial home because it's a stable environment. The next question is, are there any types of accounts, etc., where money can be hidden by a spouse so that it doesn't have to be included in the financial disclosure? I don't know if that's a family law question or if that has to do with a banking question. Do accounts in one spouse's name still become part of what is split upon separation? So the first question, are there any types of accounts, etc., where money can be hidden? I'm sure in practice there are, but when you're swearing your financial statement, you're swearing it to be true and accurate, and under penalty of perjury, basically similar to perjury. If you're hiding money in various accounts, I mean, in your financial disclosure, you have to disclose every account that you have upon separation and upon marriage. And so if you're swearing something that's not truthful, then you could get in trouble for that. Do accounts in one spouse's name still become part of what is split upon separation? Yes. So if spouse A has no assets, no debts on marriage or separation, but spouse B has an account of $50 in it, and that's all that person has, then that has to be split. The $25 goes to the other spouse. Next question, if one spouse comes into the relationship with more cash than the other, does that money get taken out of what is split between the two spouses? I guess what you're saying is, if let's say one spouse has an account of $10,000, would that $10,000 be taken out of what is split between the two spouses? That $10,000 would be deducted from that person's net family property, that person's net increased value during the marriage. Okay. Does adultery influence custody arrangements? No. Adultery does not have any bearing and will not be taken into consideration when it comes to custody and access arrangements. Unless the adultery for some reason affects the person's ability to parent, but I don't see how that would be. So no. If joint custody is decided, can one parent decide to move away from the general area? For example, if the parent family lived in Richmond Hill, can one parent decide to move downtown Toronto or further? Well, it depends on how you decide. If you decide joint custody in a separation agreement, you'll have to look at your separation agreement. If joint custody was granted by a court and the court order is silent on that, usually you have to get the other person's you have to notify the other person, and usually you have to get the other person's consent, because joint custody, like I said, is the authority to make decisions about the important aspects of the child's life, which includes where that child will live. If a spouse resides in Mexico and refuses to come back if a spouse resides in Mexico and refuses to come back for court date or deal with any responsibilities, what happens when he does come back to Canada? If he refuses to come back for court date or deal with any responsibilities, well, if he doesn't come to the court date, then I would assume that the court will find him in default and make an order in his absence, and that order can be enforced. I don't know if that's, if there's an agreement between Canada and Mexico. I would imagine there is. If one of the things that they're responsible for, you didn't really say, is child support, then there is a mechanism there's a way for you to get the court order that was made in Ontario to be enforced in Mexico, so that he would be required to pay child support. Okay? What happens when he comes back to Canada? I mean, it's a family law matter, so I don't think there's anything that would affect that. But so if he doesn't come back for court date, he'll be found in default. Are inheritances protected if the money was kept separate from the marital assets? Inheritances inheritances or gifts made after date of marriage are excluded from the calculation that we're talking about. So it would not be included in the person's net family property and would not be divided. Okay. After separation, what obligation does the other spouse have for any debt subsequently incurred? After separation, what obligation does the other spouse have for any debt incurred by whom? By the other spouse, I would assume. After separation, usually if it's a joint debt, you continue to be obligated to pay that joint debt. If it's a debt that is solely the other spouse's debt, then they are solely responsible for it after date of separation. If a spouse has been ordered to move out of the home due to domestic violence, is he still responsible for all household finances? He is responsible if he's a joint owner of the home. He is still responsible for paying half of the mortgage, half of the property insurance, and half of the property tax. What is the age of the child to be for the child support to cease? What is the age of the child? Okay, so when does child support end? Child support usually ends when the child has obtained at least their first post-secondary degree. Okay, whenever that usually that's around age 23. But if you have a separation agreement or a court order, you have to look at that, and it might determine for you in your particular case when child support would end. Okay, another question, do all personal loans, even if they're not co-signed by both parties, become part of the net worth calculation? In this case, it's a personal loan for a truck bought by my husband without my approval. So do all personal loans, even if they're not co-signed by both parties, become part of the net worth calculation? If the personal loan was taken out by the husband during the marriage, and it's, I'm assuming this is not, okay, so if it's a personal loan that existed at date of marriage, it would be deducted from his net worth calculation. If it's a personal loan held by the husband when the parties separated, then that personal loan would be deducted from his net worth calculation. So it's, if it's a loan that the husband got in both names, 50% of the loan would be deducted from the husband's net worth calculation, and 50% of it would be deducted from the wife's calculation. Does my husband, who has moved out, have the right to remove articles from our house before a separation agreement is finalized? If the household item, or if the article he's removing from the home is his, for example, his clothing, his own personal articles, then, it should not be a problem. The problem comes up if it's an item that that is in dispute between the parties as to who owns that particular item. So if you have, if he wants to take the TV and you're saying that it's also yours, then no, he should not remove it until a separation agreement is finalized or a court order is made, whichever is the case may be. Can I change the locks on the matrimonial home when there is no prospect of reconciliation and there's acrimony at the time? No. That's another aspect of the matrimonial home's special status. Regardless of who owns the matrimonial home, both parties, both spouses have equal rights to stay in the home, exclusive from or, without the other party, other spouse living there. So you can't change the locks because your spouse also has a right to live at that home. What do I do when so this is our last question. And the last question is, what do I do when the mom alienates me from our kids? How do I stop it? First of all, alleging alienation, your spouse is alienating the children from you is a very serious allegation that you have to prove. If you can prove that this parent is alienating you, or if you have concerns that the other parent is alienating you from your children, then you have to, and obviously the other parent's going to dispute that. You would have to get, a third party involved. This is something that you'd have to go to court for and get, either the Office of Children's Lawyer involved or have a court order an assessment of the children. An assessment is expensive. Having the Office of Children's Lawyer is free, but the Office of Children's Lawyer can say no to accepting your case because it is a government agency. So in other words, you have to get a third party to step in and say this is alienation and then decide on the custody and access arrangement based on that. Okay, so this is really our very last question. The question is, if I paid the lion's share of marital debt, if I pay the lion's share of marital debt, is the remaining debt still divided 50-50? Also, is further debt against a shared owned home after date of separation by the occupying spouse still also the responsibility of the spouse that has moved out? Okay, that's a lot of questions. The first part, if you paid most of the marital debt, is the remaining debt still divided 50-50? I'm assuming you're talking about that all the debts you're talking about are joint debts. If it's a joint debt, it would still be divided 50-50. But if you are the one that paid most of that, you can say that there shouldn't be an equal sharing. There shouldn't be an equal, like I said, it shouldn't be half of the difference between the two amounts. You can say that it should be less than half or more than half if you're asking for. If the other person owes you an equalization payment, you could say they owe you more than half. If you owe them an equalization payment, you could say you owe them less than half because you paid most of the debts. But that's a difficult argument to make. But that's still open to you. But if the remaining debt is a joint debt, yes, it's still divided 50-50. Is further debt against a shared owned home after the date of separation by the occupying spouse still also responsible for the spouse that has moved out? Further debt against, I'm assuming when you say further debt against, it's a mortgage or a joint line of credit that is secured on the matrimonial home. If it's a joint debt, yes, the spouse who's moved out is still responsible for it. But if you can trace, if you could prove that the further debt was incurred by the spouse who has stayed at the home in your example, then you can ask, there are ways to recalculate what is owing and making sure that that person is fully responsible for the additional debt that they have incurred. Okay. So thank you for joining us. Again, our next webinar is scheduled for January 9th at 11 a.m. And thanks for joining us for our webinar, and I hope everyone has a happy holidays.